So, for the third time today, we're going to introduce ourselves to you. My name is Ross Hersemann, organizer of CVGLS, Loading Law founder, general video game committee type person here talking to you about video game law things.
Yep. And I'm Liz. I still have my solo practice out of Massachusetts focusing on video games, but I also have other different clients too. And I am still on the steering committee for the IGDA Business and Legal SIG.
Cool.
All right. And I'm still Brandon, still trucking. Looking forward to some Chicago pizza or cheeseburgers or something after this.
Oh, don't worry, we'll feed you. This is Chicago. You will definitely get fed. For the third time today, our disclaimer: legal information, not legal advice. I'm not giving you legal advice. Today we're talking about all of the things that our game dev clients ask us, especially the indie devs. All of those first preliminary kinds of questions, issues that they go through. What do they ask us? What are our kind of canned answers? And it's going to be a broad spectrum of things today. We're going everywhere from your business incorporation to your IP portfolio management, all the way through your contract drafting, your contract perusal, how to spot a bad contract, and general finance issues, everything from crowdfunding to how to manage your business and general best practices for how to do what you do better.
Yeah, someone's talking over there.
So something's talking. We can do that. Okay. If I'm like this, can you hear me better? Is this good?
Ross's phone is just up here playing a podcast, I think.
No, unfortunately, I think it's that Doom parody video that I was looking up. No, after the last panel, I was searching for different parody games, and I found one, and it is not safe for work, and it is certainly not safe for this panel. But we can get started with the beginning of setting up your business. Indie devs come to me, a lot of them are students, a lot of them are just breaking into the industry. They have a new game idea, they've got some friends, they've got some partners, they want to get together and make something cool, and they say, where do I start? And this is where we start. Setting up your business is the way that you get started making a business. You have to have those liability shields to protect you from personal liability. You have to have some kind of infrastructure to set up how you manage your finances. Everything that you are hitching your wagon to is going to flow from setting up your business right in the beginning. And there's a couple different ways that you can do that. Like Liz, what is one of the kinds of business formations you recommend to your clients? What's the most common thing you find yourself recommending to folks?
Well, so I'll say this first. You want to talk to an accountant because different business structures have different tax liabilities. And so I recommend that, and then the accountant will work with you. They'll ask you what you envision and where you see the business going, and they will recommend what a good business structure is. And also, like, when it comes to LLCs and everything like that, this is all going to be state specific. The three of us are all from different states. So, I mean, that you want to talk to somebody from your own state and not necessarily rely on what any of us has to say.
So one note there, we do have licensure in 5 different states here, though, I think. Right?
Oh, really?
Yes.
I'm 3 and each of you are 1.
Yeah.
So we've got 5 states.
So we've got 5 covered.
5
so.
states covered. So if you're in any of those 5 states, we can help you.
Right.
Right.
So I've got Illinois covered, so if you have questions about Illinois, I'll be the one to talk to. But I know the first question that people always ask is, like, okay, I want an LLC, I want a limited liability company. That's usually the most common legal formation that I'm putting together for folks, and they always want to know what's the cost. And the good news is if you're here in Illinois, the price is now $150, which is significantly less than the $600 it used to be just a couple years ago. So it's getting a lot easier to start your own business here in Illinois. How is it in where you were from? One of the several places.
Yeah, so it's very easy to open an LLC in most places. It's starting an LLC, just forming the actual entity with the state is very easy. Forming it the right way can be tricky. Filing the document is easy, I'll put it that way. In North Carolina and Florida, it's about, I think it's $125 for the first year and then $200 or so after that. And then in California, it's $200, and then it is $800 in franchise taxes minimum every year unless you can appeal and show less. So there is a cost to doing it, but I think every lawyer everywhere will tell you having an entity set up is worth the objectively minimum, or maybe not objectively, but minimal cost it takes to maintain it every year. That said, I will say, in addition to thinking about the accounting implications of LLC or what type of tax selection you make in an LLC, having a corporation is my recommendation for a lot of my clients. Because having a C corporation enables you to do things that an LLC, while it might be technically able to do, is not the preference of the person you're on the other side of. So for example, if you're going after venture capital or you're trying to get certain types of seed investment, they don't want to see you with an LLC. You can still form as an LLC, you're just probably going to have to convert into a C Corp later. And if you know that you're going to be doing that in relatively short order, it makes sense just to set it up that way from the beginning.
Definitely, and that speaks to like the different kind of company that you're putting together as well. And I don't mean capital C, I mean lower C. What kind of business you're running, because depending on your long-term goals, if you know you're going after VCs or capital funding, you can make that determination early on. One of the advantages of an LLC, especially for folks starting out, is how easy it is to transfer it into something later. So it can it's a business that grows with
So
you.
that is state specific though. I will tell you, some states it is actually not as easy just to convert from an LLC to another entity.
Okay.
You have to create the new entity and merge the two and then dissolve the old one. It's a disaster. So that is state specific, yeah.
Yeah, so Illinois, it's easy to do that, but in other states it might not be. Yeah.
Right, and LLCs versus corporation versus C Corp or S Corp, they have different requirements for governance. So if you have an LLC, depending on how you run your studio, you may or may not want to bother with official annual meetings and meeting notes and things like that, shares of interest. S Corp or C Corp, they're going to have more stringent requirements for procedures that you have to do on a regular basis, so that's something else to think about. Corporations are cheaper to form in Massachusetts, but you do have to have all those headaches that I just mentioned. LLCs in Massachusetts are brutal. It's $520 per year, and so a lot of people sort of lose track of the fact that you have to re-register every single year. But do keep that in mind for planning purposes.
And that initial formation, most of the time, is the easy part. It's that subsequent management that becomes a headache for folks, because I'll have a lot of clients who are proactive and they'll say like, oh, I can just file my LLC myself, and I'm like, yes, you can do that in Illinois. Yeah. But what comes next is where you might need some expertise. That's when you want to start talking to an accountant, to a lawyer, setting up things like your operating agreement, the general document that sets out all of the rules for how your business is formed, the names of all of the people involved in your company, how they are contributing capital, in what ways, how you handle dissolutions or disagreements or any other kind of issues your business might face is all going to be laid out in that document. And it is not something that comes naturally to most people from a drafting perspective. It's not something that's easy to just pull off of Google. It's something that requires some special attention. So that's one of those areas where you want to be talking to professionals.
So just on the formation piece, I mentioned that it's very easy to file the initial paperwork. What it's not easy to do is get the company set up internally, especially if you have more than one person. That relationship is like a marriage, right? You're getting into business with someone. You need to be thoughtful about how you're doing that. If you're doing it with a lot of people, obviously it gets more complicated. Can any of you read these at all? No. Okay, I didn't think so. So I'm gonna mention some of what they say there. So The first bullet point there is operating agreements and governance. Those two are listed separately because operating agreements, as Ross mentioned, are sort of they're your agreement between the company and all of the members in an LLC about how the company's going to work, how the equity works, all of that. Governance is listed separately because depending on how you form, if you have a partnership or you have don't make a partnership. But if you have a partnership or you have a C Corp, you're going to have a different set of, it's not going to be an operating agreement. It could be a partnership agreement, it could be bylaws, but it's still going to set forth, how the company deals with itself in terms of finances and, meetings and that sort of thing. The next bullet point there is initial equity agreements. I think I added this to the slide. This, I think, is often overlooked with new founders. Your initial equity agreement, if you're forming an LLC and all you have is an operating agreement, you've formed your LLC and you have your equity, and that the job is done. The initial equity agreement is required if you have a corporation, but if you have even if you have an LLC, I often recommend that you have some sort of initial equity agreement. The reason for that, if you have more than one founder, is usually vesting. So vesting means that you don't necessarily have all of your equity today, right? You have it, but the company can buy it back at a very low price until you vest. And you might vest over a period of a few years or a few months or whatever, but what that does is it creates an incentive for everybody to stick around. If you have a team of 5 or 6 people, and you've looked at this and you've said, well, you're the artist, and you're also an artist, and you're also an artist, and you're a level designer, and I'm the programmer and the game designer, so I should get 50% of the company, and you should each get 10 or whatever, right? That sounds great until you realize that if that artist leaves tomorrow, that artist still has 10%, right? Unless you've put in place some mechanism for preventing that from happening. There are a lot of different ways to do that, but without something in writing that establishes that, you're not going to get that equity back from that person without that person agreeing to it. The next point there is contribution of pre-existing assets. I know a lot of the indie developers I've worked with have started making the game before they've made the company. And if you don't put something in writing that says everything we worked on before now belongs to this entity, it doesn't. It still belongs to the people who worked on it before that. So that's why I added that, I think. Yeah.
Absolutely. I know a lot of my clients fall into kind of that situation where a lot of them might be graduating from a game design college, a programming college, and they have a senior capstone project that they now want to turn into a portfolio piece. They want to take solo and they want to build an LLC around it. Brandon's absolutely right. If you don't have that kind of agreement in place, the IP ownership could be according to whoever made some particular asset. And chances are that person might not be affiliated with this new LLC that you've made, but you don't want to be in a situation where 5 or 10 years from now they're going to say, oh, I'm here for my 10% of whatever we made.
Right, and that document is called an assignment of copyright, so that's really important. And we do see this a lot in the indie space. Something else that we see that is a foundational issue is if you have a current employer, if you have a day job, or if you've had one fairly recently, or if you work in academia or something like that, you want to take a look at your employment agreements and any sort of documentation to make sure there aren't any clauses in there that say any inventions that you create outside of work belong to us. So that's something that can come up depending on what industry you're in already.
Absolutely. And once you actually get your business together, then there's everything that comes next. They're setting up your federal tax IDs. They're setting up all of your bank accounts so that you can actually start doing business using debit cards, using credit cards. All of that account management, you need to either find an accountant or get a hold of some good finance management software so that you actually know what money is coming in and how it's going out. Now, as an indie developer at the beginning, that might be zero. And very often it is, but that still means that you need to keep track of that information. Even if it's a column of zeros, you need to know what's happening.
Not only that, you have to have a separate bank account. If you have a business, but you're funneling it all through your personal bank account, having that liability shield for the business is kind of useless because you're commingling the money. And so plaintiffs' lawyers who might sue you at some point can do what we call piercing the corporate veil and go straight through to your personal assets, especially at least in that account and maybe everything else you own as well.
Mm-hmm. Yeah, in Illinois, the way that that's taxed is we allow for single member LLCs, so you can have your own business, you can have your own LLC all by yourself, but that finance is still going to be taxed as if it's your personal income, and that might not be something you want to happen. Now, following getting your bank accounts together and all of your account management, you want to make sure that you have the proper insurance and business licenses. And this is something that a lot of folks tend to forget about. Depending on what kind of business you're in, it might not be a development studio, it might be a VR arcade, or some other kind of business that's game adjacent. You need to make sure that you have the proper business licenses and insurance. If you're running a physical space where people are coming, if you have a bar, you're going to need liquor licenses. You're going to need all kinds of liability insurance for injuries that might happen in that space. And it's one of those things where you have to think outside the box on it because a lot of these things aren't foreseeable. So in addition to talking to a lawyer and talking to an accountant, now you probably have to talk to an insurance representative to make sure that they're covering you on all of your bases.
But don't worry, they'll find you.
Oh, they will. You don't find them, they find you. It always happens. So now you have your company, you have your bank accounts, you have all of your account management software, you've got a team of professionals behind you backing you, making sure that you are doing all of the right things. Now it's time to establish your company culture, which is becoming more and more important every day in all the conversations that we have about unions and harassment and privacy and workplace culture. You have to make sure that you are crossing your T's and dotting your I's on having an employee handbook, having employee rules. If you're starting a business, not necessarily working for someone else, Liz mentioned making sure to read your employment agreement to see if someone else might have claim over your IP. Now you're kind of creating your own institution. You have to figure out what kind of company culture you're going to have, how you're going to be working with your employees, what your policies are going to be on controlling things that they make, that they're moonlighting, what their office relationships are going to look like, what the procedures are for that. And again, you have to think outside the box here for any potential situation that might come up. It's something that a lot of indie studios, if we're talking 3 or 4 people, are not going to be that heavy from a drafting perspective, but as that business grows, you're going to start encountering a lot more new issues and new situations that you're going to have to account for.
Yeah, so this is not my list. This is a list I just pulled up from somebody else, but I'm going to run through a few statutes here. So when you have 1 employee, you have to comply with the Fair Labor Standards Act, Papa Bad. Uh-oh, no thanks. The Immigration Reform and Control Act, the Employee Retirement and ERISA, the Employee Retirement Income Security Act if you provide retirement benefits, the Federal Income Tax Withholding Requirements, the Federal Insurance Contribution Act, the Equal Pay Act, the Uniform Services Employment and Reemployment Rights Act, the National Labor Relations Act, Uniform Guidelines for Employee Selection Procedures, Employee Polygraph Protection Act, Sarbanes-Oxley. That actually should not be on that list at 1 employee, but if you're publicly traded and have 1 employee, I guess you'd have to comply. The Consumer Credit Protection Act, if you're doing background checks, Fair and Accurate Credit Transaction Act. This is all at 1 employee. At 11 employees, you now have new record keeping requirements. You have to comply with the Occupational Safety and Health Act. You also have to maintain records of compliance for different things. At 15 employees, now you have ADA, you have Genetic Information and Non-Discrimination Act, you have Title VII, which is all of your other discriminations that you're used to hearing about. At 20 employees, you have age discrimination and consolidated omnibus budget reconciliation, aka COBRA, which is where you have to provide certain types of health benefits even for departing employees. At 50 employees, you have the Affordable Health Care Act, Family Medical Leave Act, Affirmative Action Programs. At 100 employees, Worker Adjustment and Retraining Notification Act. That's WARN. That's the layoff thing that we heard a lot about in the last 2 years with different game studios. And EEOC compliance. So you can see at the startup level is when most of those things hit. Like the day you hire your first employee, you have to comply with a whole bunch of new laws, right? And it's important to at least have some understanding of how that works. The slide says company culture and then under that HR. I would actually flip that around. I would say HR first and then think about company culture. Do the minimum compliance, and there are a lot of different places you can do this now. There's a lot of software solutions that will take 90% of this off your plate, believe it or not. And then think about company culture, right? What you don't want to do is get sued because you inadvertently left some money out of a 401k plan that should have been in it or something like that, right? You want to make sure that that is taken care of if you're offering those benefits.
Mm-hmm. Absolutely. Very well said. And it just speaks to a larger point of, I've noticed with a lot of my clients in the indie scene that there is this mentality of taking everything on yourself and being a jack of all trades and being able to do everything yourself. And that's fantastic if you are a polyglot and you can handle being a programmer and being an artist and also handling your finance. Like if you have the capability to do all of those things, that's fine, but you still only have 24 hours in a day. And that entire list of all those statutes we went through, no one person can handle all of that for a company all at once. You're going to have to spread the load around and handle it with other people because there's a lot of things that you need to be aware of. General best practices. It just sounds like
I think we hit them.
I think we hit them.
Know what you don't know.
Yes, that's the hard part. Now, intellectual property. We've had a couple panels today already talking about intellectual property. We've talked about trademarks and patents and trade dress and copyright. Be aware of all of those things and what they mean. And I think after today, I think everyone in the room has a pretty fair grasp of how that affects your practice. Copyright, of course, applying to any original work of authorship fixed in a tangible medium of expression. Any creative content that you create is going to fall under the realm of copyright. Trademarks and trade dress, all of those brands, all of those indicators of a source of origin, whether it's for your goods or your services, the words that summarize your company, your business, your game, or the logos and designs that apply to it are going to fall under trademark. And of course, patents applying to all of those processes, be they mechanical or design, that applies to what you make. Be aware of those things and take steps as necessary, because it's going to fall into enforcement, things that you're doing to make sure that you're protecting your own rights, and infringement, things that you should not be doing. Don't do that. Make sure that you are not infringing on other people's property, whatever it is. Best practices, be the best. Be the best, keep it going. Contracts. This is where we spend most of our time for independent development. The legal world runs on contracts, and for indie devs especially. Brandon did a great job talking about all of the things you have to do to make sure you're in compliance with existing frameworks of law. And employment agreements are one of the first places that you do that. That's where you lay out all of those rules for people who work for you, not only what you expect for them to be doing for you, but also what their benefits are, how they're paid, when they're compensated, all of the benefits that they're getting from you. What are some best practices you've both encountered with independent contractor agreements? Because these are a little bit more nuanced and definitely not as standardized when it comes to different people.
Yeah, that's happened a second time today. All right, so first of all, you want to actually specify that this person is an independent contractor. So the difference between independent contractor and employee, and as we found earlier, employees carry a lot more responsibilities on behalf of the company. So for an independent contractor, you need to give them control over how they do the job, they do it using their own resources, etc. It varies by state. But you want to have clear and unambiguous language saying that this person is an independent contractor, and any work product that they create arising out of this agreement is a work made for hire, which means that the company owns the copyrights and all the works and not the contractor.
Definitely.
Yeah. So those are just two. I'm sure Brandon has a whole list.
Yeah, I could read somebody else's list. No, what I would say, I think one of the key things you just mentioned there is that it is state specific. And it's not the state you're in that's going to govern your relationship with an employee or a contractor. It's the state they are in. So, we live in this connected world and everybody thinks, well, I'm in Illinois or I'm in whatever state. I don't care that my half my team is in California where, I'm hiring them from. California law doesn't apply to me. It does, and they will come after you if you don't comply. And California, on that note, starting next year, has a very different definition of what an independent contractor is. And it doesn't matter if this is true of every state, but it doesn't matter if your agreement says you are an independent contractor. That's one factor. All of the other factors come into play. In California, that is not even a factor anymore. It doesn't matter what the agreement says. It's just about the relationship. They've got what they call an ABC test. There are some exemptions to that for things like fine artists or freelance journalists, but for the most part, it's a whole different regime out there, and it's very state specific. And it's also country specific. If you're hiring a Canadian contractor, Canadian law applies to that relationship, whether you want it to or not.
Absolutely. Think of it this way. The work that they're doing is going to be in another state. They're entitled to all of the protections their state offers them from a labor perspective. So you need to be in compliance with that and be aware of that. And that's very complicated in the current landscape we're in, where people are going to have an artist in another country, a programmer in another city. I've seen lots of international teams being put together for indie studios, and that's fantastic when it comes to collaboration, but it becomes a very real nightmare when you're trying to consider all of the different implications it has on your business.
So how do your clients typically cope with that?
Well, there's a lot of crying, there's a lot of screaming, and then a lot of questions afterwards. And we try to work through it as much as possible. But it's one of those things where I've heard some really creative solutions from clients that are not practical ones. Something as simple as what if they took a vacation to visit me here in Illinois and they did all their work while they were here? Now are they not a foreign, independent contractor? And then I stop answering questions like that.
And on that note, if you're going to take an approach where they come to visit you in Illinois and they're in, who knows where, outside of the country, that's a business trip. It's not a vacation. So you need an immigration attorney, or at least you need to know what kind of visa you're bringing them in on. None of us do that for a living, so don't ask us questions about that, but we all know people who do.
Yes.
But if you're bringing a worker to the U.S. to work, it's not a vacation. They can't come on a tourist visa. Both you and they can get in trouble for that.
Yeah, points for trying to be clever to make that work, but the people evaluating on whether or not that's going to fly will be absolutely humorless.
It was actually, it was a big problem in the esports industry for a little while. Now they've figured it out a little bit better, but, a little bit, yeah, Nate's given me the little bit. But, players coming to the U.S. to play in tournaments would just get tourist visas. But they're not coming to, vacation. They're coming to do what they do for a living. So that's not a tourist visa, right?
So this is interesting. So is there any kind of distinction when they're playing games for work or when they're playing for recreation?
I'm sure there is, but if they're competing to get paid, I don't think it's,
Yeah, it all falls
Yeah.
under that umbrella. Right?
Yeah, I think, and again, not an immigration lawyer, and there are about 4 different types of visas that the esports players try to come in under, and I don't know the difference or anything, but it's a situation. Be aware of it. Right.
Right. Yeah. So if you can tell from our level of apprehension with this information, you should know where you should be. Any other thoughts on independent contractor agreements or visas before we move on to the next thing?
There are so many potential provisions to put into an independent contractor agreement. It's impossible to go over all of them here. But you definitely don't want to confuse independent contractor with employee. Again, employment agreement is not the same thing as independent contractor agreement. But that could be a seminar for 2 hours at least. So we'll, if there's any questions after we're done, feel free to bring them up.
I think we saw one already.
Yeah, I have a question about internship. Like, if we hire students, fresh out of college as internship for 2 months, and after that we're satisfied with his performance, we want to bring him full time. So that 2 months internship, will he be considered a contractor or an employee?
Ooh, I'm not a labor attorney, so
Yeah.
I'm not the right person to ask that.
So
but he'll be an intern. I
I'll
think.
give you the information without answering the question. So the information is it depends on the state you're in. It also depends on whether or not you're paying them. And if you're not paying them, there's a whole different set of things you're going to have to comply with. So look into it is the answer. Maybe.
That's fair. That's fair. And that's a good segue for non-disclosure agreements, which is something else that comes up often. When my clients ask me about non-disclosure agreements, it's usually because they're getting ready to do play testing. They have a product, they want to share it with people, get some feedback, and they want to make sure that everything they made stays secret and stays safe. They want to make sure that their idea, their brilliant intellectual property, doesn't get spread too far or too wide. And something that I always remind them is that non-disclosure agreements come in a couple different flavors for a couple different purposes. It's not always as simple as, okay, I'm going to show you a thing, keep it a secret. A lot of times they kind of work as a two-way street where you have a mutual non-disclosure agreement where someone might be showing you something and you want to make sure that it's secret, but at the same time you're sharing something with them and you don't want to keep it secret. Where this could happen is, imagine a scenario where you work for a company and someone comes in to pitch you an idea for a product that they might want you to sell. If you're a game studio, they might have a great idea for a game, they might have a prototype, they might want to use your IP to do it, and they might want to show it to you. They might later on want to take that mechanic and reskin it and take it somewhere else, and they don't want you to hold on to that, and at the same time you might share with them some intellectual property that you don't want them to run away with. A mutual non-disclosure agreement is something there that's going to protect both parties. It's not a particularly difficult document, but from a drafting perspective it does have to take into account that both parties are exchanging confidential information. I always have to say a word about licenses. When we've talked a lot about intellectual property today, licenses and assignments are two different things. A license is when you're giving someone permission to borrow and use something, but not necessarily own it. An assignment is when they are going to be taking on an ownership right. And that distinction is very important when you're talking about how things are shared and how people are being compensated for various things. Does anyone have any horror stories or positive wins for licenses? Those are usually some of the more straightforward things I work with.
Licenses can take a lot of forms. I think the biggest license agreement in most indie startups world is going to be a publishing agreement. Publishing agreement might also take the form of a funding agreement. You might be funded to do the development, which might also be a license. But they can take a lot of different forms. I think the spotting bad contracts would also, which is the next bullet point, will also apply to those sort of license agreements. So I'll just wait.
Right.
So licensing can take a lot of different forms, like they said. It is very common for indie developers to want to put someone else's content into their game. So for example, there's a song by an artist that you really like, you think it really fits the game, so you put it into the end credits. I wrote and spoke a lot about the Alan Wake situation a couple of years ago. So Alan, the developer of Alan Wake Remedy, they licensed a few songs from this band, Poets of the Fall, because they felt that those songs were just so integral to the story and so integral to understanding Alan Wake, the character. So those licenses sadly expired, and the game went on a deep, deep sale before it was removed from Steam, because Remedy decided if we can't have the game up with those songs, we might as well just not have it up at all. So with your licensing agreements, you want to be really careful to define what rights that you are going to get from the licensor, the owner of the copyright, because copyright does carry with it a certain bundle of rights we like to talk about. The right to distribute, the right to reproduce, et cetera, and the owner can give those out how they choose. Duration, territory, things like that, right of first negotiation, all that other stuff. So I mean, that's another topic, can of worms, that could go on for a couple of hours.
Definitely, but that's a really good segue for spotting bad contracts. Bad contracts aren't always bad because they're predatory or because someone on the other end of the bargaining table is malicious. Sometimes the worst contracts I see are bad because the people writing them weren't lawyers or because they didn't know what to include or not include. I think the worst contracts I've ever seen are ones that are pulled and applied to situations where they shouldn't be, where they are including language or jurisdictions or references to unique law that just doesn't apply to the situation at hand, and it creates this hot mess of an agreement that really doesn't cover anything, doesn't protect anything, and just creates more headaches than solutions.
Right, so there is a music licensing contract that is floating around in the indie game circles, and a few different clients have brought it to me. That form agreement has everything in the kitchen sink in it. It has movie rights and all kinds of other things that are not going to apply to most indie music composers. It is harder for me, it is more onerous for me to edit that for someone's specific tailored situation than it is to just write my own contract from scratch. So it is tempting, you may think you're saving money and time, but you want to be really careful with any kind of form or anything that you get from somebody else because every situation is different.
Yeah, so to that point, this is blanket advice that applies in 99% of the situations. Don't pull a contract off the internet without reading it and assume that it fits your situation, right? Even if you've read it, make sure you understand it, but probably just don't pull it off the internet. It's probably better to write down what you actually mean in plain English and have the other person write down what they actually mean in plain English and combine that and make sure you're all on the same page and sign that, than to pull something off the internet that doesn't say what you think it means, or doesn't actually say what you think it does. Because a little primer on contracts law, there's something called a unilateral mistake, which is you making a mistake about what the contract says, but the other side knowing what it says and intending the meaning. And in that case, they can enforce it against you, assuming that you both had an equal hand in drafting it. Then there's something called a mutual mistake. And if neither one of you really understands what the contract says and you sign it anyway, you kind of might as well not have a contract. And at that point, what do you have? You probably should have just started with real terms that you actually understood, right? And so to that point, make sure you understand your contracts, even if you have a lawyer draft them. Make sure your lawyer is explaining the contract to you in a way that you understand that what your lawyer did matches your expectation of that, right? And some lawyers are better at that than others. Some lawyers will just hand you, frankly, the same template you could have pulled off the internet, and you should find a new lawyer if that happens, right? But if you are reviewing a contract without a lawyer, I like to say to look out for ogres. And it's a bad acronym, but it's an acronym, so I'll run through it. So look out for what your obligations are. That's your O. What do you have to do under this contract, right? Then look at what you're giving away. That could be rights in your game. It could be, the ability to enforce something. Whatever it is, look at what you're giving away. Look at what you're getting. That's a second G, so we're misspelling ogres a little bit. So look at what you're getting in return for what you're giving away. Then we have the R, which is look at what your representations are. So representations and warranties is a legal word that basically means promises. So look at the section called reps and warranties and look and see what you're promising is true and make sure it's actually true. Because that's a quick way to have an indemnification obligation or to be in breach of the agreement before you've ever even started performing under it. And then the last thing is exits. How do you get out of this agreement if you need to, right? And maybe you don't have any and maybe you don't need any, but in some situations you might want some, right? So those are your ogres.
Right, and something else you want to think about, like all of these different contract terms that you may come up with or that a lawyer may come up with, you should really have a good understanding of why you want them, because that will help you say if the contract from the other side has deal breakers in it, that will help you decide what you can and can't live with.
Definitely. And that's a really good segue for like general best practices, because we're talking not just about good contract drafting, but also why, higher arching policy of what do you actually want your contract to do. And that you take that philosophy and let that trickle down into everything else that you're doing. So for your business and financial practices, organizing for diligence, and then even getting into crowdfunding and raising money, remember why you're doing things, and then let that function follow the higher arching principle. So organizing for diligence, Brandon, what can we do with organizing for diligence? What are some good best practices starting there?
Yeah, so organizing for diligence. Who knows what diligence means in the corporate sense? We got Mark. We got a couple. So diligence is when a potential investor or a potential acquirer comes into your company and looks at everything you've done to decide if it's worth investing in or buying. And when they do that, they're going to look at every contract you've ever signed. They're going to look at every financial transaction you've ever had, and they're going to scrutinize those. So when I say organizing for diligence, what I mean is from day one, making sure that you have all that stuff in a place that's it's organized and accessible. And I say this even if you're not actually going after fundraising or an exit. And that is really important because let's say you get audited by the IRS. You don't have to go and spend 3 months getting ready for the audit. You can just hand it to the accountant because you've already done the work to prepare for that, right? Alternatively, maybe you're not out looking for funding or you're not trying to sell your company, but one day a big publisher or a big investor or a big acquirer comes along and says, I want to hand you millions of dollars. Can you set up a data room and show me everything about your company in the next few weeks so that I can decide if I want to hand you the millions of dollars? If you're already organized that way, first of all, you look really professional when you're able to just flip a switch and suddenly, hey, here it is, take a look. That's going to increase their perception of the value of your company, right? And then also, the flip side of that is true. If they say, hey, I want to hand you millions of dollars, flip this switch and let me see this stuff, I'd like to see it in the next week or so, and 3 months later you can't get it together, they're not going to buy your company, right? Because that's a sign of how you've run things from the beginning. So crowdfunding is the next one.
That was perfect. I have nothing to add. That was good. Yeah. Crowdfunding is one of the first things that I always hear about from my clients. Usually they have their project and they're like, okay, we've been working on it for a little while. We need a little extra money to really get over the hump. We need 10,000, 20,000, whatever the number is. We just need 9 months worth of burn rate so that we can get through and finish this. And when we reach that point, then we'll be that much more attractive to publishers, to investors, to other people. Crowdfunding is one of the more complicated things that people go through because I think they underestimate how much work it actually is. It's not as simple as just taking your executable file, making a 30-second video, and creating some fun reward tiers with t-shirts and posters and other things and saying, all right, time to get some free money. It's also not free money. It comes with strings and obligations. You have to be very forthcoming with your entire development process. And when you're putting together your crowdfunding ask, you have to make sure you're including things in there that aren't as simple as paying your rent. Your crowdfunding ask should not just pay for your rent while you're developing something and working somewhere else. You should really put together a very itemized list with very practical numbers about all the finances that are involved. So that could include hiring lawyers, hiring accountants, hiring marketers. It'll include everything from play testing to all of the brand management that you're going to be doing. And also keep in mind that when you're signing up for crowdfunding, you're signing up for extensive community management. It's going to be a big time suck. You're going to be working with constant updates, drafting emails, tweets, social media posts, reaching out to your backers and communicating with them, because whatever expectations you set, you have to meet. If you tell people that game is going to be done in 2 years and they're going to have a copy of it in their hands with an art book and a t-shirt and everything else, and you make a silly mistake like you forget to ask for the amount of money to ship those items to them, now you're on the line for shipping those items to them.
You promise 5 different size t-shirts.
Mm-hmm. Yeah, you have to plan for all of that. You have to get it all set up ahead of time. It's a lot of front loading.
Yep, and the platform takes their cut too. So not only do you have to purchase the blank t-shirts, you have to pay to have them screened and then pay to have them shipped and all this and that. And that's for every single physical prize that you have. If you're giving away physical copies of the game, you have to have them manufactured somewhere, and that costs money. And there's also the tax implications. Don't ask me, ask a tax attorney. So it's much more expensive and onerous than it's commonly made out to be, and typically the big multi-million-dollar successes are people who already have a lot of hype behind them. It's Obsidian, it's Tim Schafer.
Right. I mean, don't use that as your step one for marketing. Don't think that a Kickstarter is just all of a sudden going to be all of your marketing in one shot. Likewise, sending a copy of your game in progress to a famous YouTube streamer and saying like, hey, play my game, and then hoping that somehow you're going to go viral and sell 1 million copies is not a realistic expectation. That's not a plan for success. You know, it's really about pounding the pavement, and any kind of crowdfunding platform that you're on is going to be speaking to an audience you already have. It's not necessarily going to be opening you up to a new audience. You just have to really understand what you're getting yourself into, because it's something that takes a lot of time. And you have to plan for that ahead of time, because you might not... It's very hard to switch gears, is one of the things. Like, once you start that process, it's very hard to switch gears on platforms. It's hard to kind of change expectations. Scope creep is one of the biggest nightmares when it comes to kickstarting and crowdfunding in general, because if you want to add some cool feature, it might take you an extra year, and now you've alienated half of your backers. We could do a whole panel just on crowdfunding.
Yeah, that's a pretty common theme for this panel. We could do a whole panel on everything we cover in the panel.
That's true. But in the interest of time, we can just kind of power through publishing versus self-publishing. A lot of indie developers in the room. How many, raise your hands again, how many of you are developers or would identify as indie? A handful? Okay. It's very sexy to work on the notion of self-publishing. You know, with app stores and the ease of access to a lot of these platforms, people might say to themselves, I can just upload my executable to this mobile store, that mobile store. I don't need a publisher. I can just put it out there and my game's great. People will find it. And more often than not, publishers are more marketers than people putting out a product. They're going to be doing a lot more than just getting you onto the app store. They're going to be using their connections and their expertise to put your game in front of the right people at the right time. So that question of, you know, publishing versus self-publishing, do you need a publisher? What do they do for you? Oh, that's a big bite, but like, if you had a soundbite, Brandon, like, what would you say to folks about publishing versus self-publishing?
So I would say publishers are a multi-headed hydra, right? There are some publishers that are great, and there are some publishers that are terrible, and every time a terrible one is killed off, and 2 more terrible ones show up, right? But there are a lot of great publishers, and so with publishers, it's important to know why you're working with that publisher specifically and what you expect to get out of that, right? So as Ross mentioned, like, publishers often perform a lot of the marketing function for you. Not all of them are that good at that, actually. Some of them provide other value instead of that, but yeah, so publishers can perform marketing, they can do localization, they can take QA and testing off your hands a lot of the time. But the more hands-on a publisher is, the more they're going to ask for, right? If all they're doing is marketing, they should get a relatively small percentage of your game. If they're hands-on from the beginning, they're funding the game, you know, they're going to take more. And if they're putting all of the money up front in the beginning, so if they're handing you millions of dollars so that you can go out and hire a staff that's, you know, super talented and develop a AAA, not even AAA, a good indie title, right, for a couple $1 million, they are going to ask for a lot of the money, at least initially, until they recoup their money, and then, you know, you'll get more back after that. But the more they're doing, the more they're going to take, but just make sure that that aligns with what you want it to be. I would also say that your second publishing deal is going to be better than your first publishing deal, because you're going to make mistakes in negotiation, and if the first game does well, you're going to have a lot more leverage in that second negotiation.
Absolutely, absolutely. And, you know, we've talked a lot about publishers and self-publishing and also crowdfunding, but also don't discount just the plain old-fashioned small business loan, or, you know, your rich uncle when it comes to financing your game, because...
I would also like to meet your rich uncle.
Yeah, me too. I mean, we all would. Because those sometimes are better for you in the long run. I mean, you have to really look at the fine print on any publisher who's giving you money and what they're taking for it, because remember, they're going to take their bite, but then whatever platform you're on is also going to take a bite. So you might be looking at a contract that says you only get to keep 20% of all the money based on your game. It might be that much simpler to talk to a small bank or, you know, some relative and get that money that way. It might come with some different strings, but those strings might be better than you might see from somewhere else. Use your thoughts.
Right. Explore the options is what he's saying.
Yes, do your due diligence. But I want to leave a lot of time for questions, general questions, and also potentially some less general questions. But is there anything that we talked about in the last 40 minutes or so that triggered some belly fire? Does anyone have something that they really want to ask?
Never heard it phrased that way.
Never heard it phrased that way.
Like
First
that.
time ever here at CVGLS 5. So I can tell it's the end of the day. It's real quiet back there.
Well, here's something I came across that I think a lot of indie developers will might want to know at some point. So I filed a trademark application for a client, intent to use. He came out with a freely downloadable vertical slice demo. I talked to the trademark because there was this is a good specimen of use. We have that deadline coming up. The response was, I'd have to look into it, but probably not. And that seemed wrong to me. And I was wondering, has anyone ever come across a similar issue? Because that's, if I can save a couple extension fees, that's awesome. But at that point, it probably would have taken more money for me to do research and argue with the trademark extender, and then have to buy extended possibly anyway. So I didn't know of any actual examples offhand of that.
Yeah,
Or
I think you and the examiner both have good arguments. It gets down to the crux of, is it used in commerce, right?
Right.
If it's a freely available alpha that's not really distributed for benefit to the company, the examiner might be right. Might be. I don't know. Mark may have other thoughts.
I heard that question too, and my answer is very similar to yours. If I had to pick one or the other, I would say that a playable demo should be considered goods in commerce.
Yeah.
But I could see an argument the other way.
And the worst part is, in the examination manual, the answer is basically beta software. Maybe.
No, you're not wrong, and it's one of those situations where I've been in a similar situation with clients, and they'll ask me, can we get this on the books? I really want this trademark as soon as possible. I want to start doing things with it. I want to start, enjoying the benefits of it. And I have to say, well, it's, kind of an examiner's best guess, and I'm not the examiner, but whether or not your goods are in commerce. And they'll say, well, I took it to this convention, I showed it at this conference, it's available on this platform's, early access, whatever version that is, and it's a sticky situation because it's not always
If it's
cut
a
and dry.
paid early access, absolutely.
Right.
Yeah.
Right. No, and the paid is an
Yeah.
important part of that because sometimes it's not paid, and sometimes it's how far reaching is it really?
That said, not every examiner is as thorough as every other examiner. So.
Yeah. That's the other gray
That's
area
why
is, not all examiners are created.
Well, I mean, honestly, so this is being recorded. Talk to me afterwards.
That's fair. That's the other answer to every question we have today.
I have some tips for you on that. Not that I've never once tried to defraud the PTO, and I don't intend to start now, but I have some tips for you.
Other thoughts, other questions? Yes.
I know Brandon threw out really briefly not to form partnerships, but can you go just a little bit into why?
Yeah, so a partnership, unless you've registered a limited liability partnership or its equivalent in your state, if it's just a partnership, it doesn't provide you any liability shield the way that an LLC would, or the way that a corporation would. So that your personal assets are at risk. The other reason not to form a partnership, or if you do form a partnership, to have good governing documents, is that in a partnership, any individual partner can bind the entire partnership. So if you form a partnership with 6 people, and then one of them goes rogue and signs a publishing agreement without telling anyone, that publishing agreement sticks. So there are pretty good reasons not to sign not to have a partnership. The other thing that's important to note about publishing, I keep saying publishing instead of partner, about partnerships is that if you don't have any other entity formed and you are working with other people on a collaborative project, you've formed a partnership, whether you want to or not. So go out and register something else so you don't have a partnership. Does that answer the question?
Yes,
okay.
thank you.
Sorry.
All right. Any other questions so far? Cool. Well, if you have any specific questions, you can come and find all of us after this panel. And with that is the last panel of the day. Thank you. This has been CVGLS 5, everyone. Thanks for coming.
Thanks for